I understand we have 208 people registered and attending the event today, which is a fantastic turnout, and thank you. I'd also particularly like to thank and welcome Sadaf Ashraf, who is Secretary to the Sheku Bio Inquiry, and Kira Pang, who I understand are also here today. She's the Deputy Solicitor. Sorry, Sadaf, did I say you were the Deputy Secretary? Solicitor. Welcome to what is the first ever Compass event, which has not involved us providing alcohol after the Q&A today. Although I understand, having spoken to some of our speakers, that they may have BYOB'd already. This event was originally planned in March, and that to me seems like an absolute lifetime ago. It was a brave decision, we thought at the time, to cancel because of COVID, but I think in hindsight that was very much the right decision. So we have 5 fantastic speakers for you today, and I am delighted and honoured to have Sir Anthony Campbell here, and I'll be introducing him properly in a moment. But we also have other members of Compass Chambers, and we're lucky to have, and hopefully you'll see all of them on screen at the moment. We have Peter Gray QC and Steve Love QC, and we also have Amber Galbraith QC, who took Silk this year, and we have Emma Toner here also. And they all have considerable experience with inquiries and public inquiries in particular, and they're here to share some thoughts with you today. So I don't want to go on for too long in welcoming you all, because I know it's tiring watching Zoom. So I'd like to turn first of all, without further ado, to our first speaker, and that is our keynote speaker, Sir Anthony Campbell. Now, Sir Anthony was, as many of you will know, a judge in Northern Ireland for many years, and also a Lord Justice of Appeal. And he's been involved in 2 inquiries in Scotland, which we've been very grateful to have his involvement. He was involved in originally the Chocar inquiry, and his report was laid before the Scottish Parliament in 2001, and that related to the death of Surjit Chocar. And it was a report commissioned by the then Lord Advocate, Colin Boyd, now Lord Boyd. And in addition, he was the chair of the fingerprint inquiry, which he was appointed in October 2008. And this was a public inquiry set up by the Scottish Government into the events surrounding the trial of Shirley McKee and the circumstances surrounding the alleged finding of her fingerprint on a door frame where the murder victim was found. Now, I had the benefit of appearing for the Lord Advocate in that inquiry, and Amber also appeared on behalf of Shirley McKee in that inquiry. And we both agree that the fingerprint inquiry was what we feel one of the gold standard in terms of how these things should be run. And so when we were looking for an ideal keynote speaker, the only person we thought of at that time was Sir Anthony, and we're delighted that he's here today. But he doesn't view Scotland only in a one-dimensional way, involving highly sensitive and very politically sensitive and anxious cases. As I understand it, he also loves Scotland, and he's had many an enjoyable holiday here over the years. But I understand Scotland has provided him and his family with effectively some respite over the years because of the overwhelming security which he's had to live under in Northern Ireland in his role as a judge. So we are delighted to have you here today, Sir Anthony, and look forward to hearing your comments. And I think we'll just turn to you for your words. Thank you.
Thank you very much for your kind introduction. It's very nice to be back in Edinburgh in spirit, if not in body. But as you said, I have a great affection for Scotland and good reason for it. Many years ago in 1995, Lord Justice Scott, as he was then, gave an address to the Chancery Bar Association. And he made a number of points, and many of these points were incorporated into the Inquiries Act in 2005. But I think it's worth repeating them now because it helps to focus, in my view, on the real core needs for a public inquiry. The first point he made was that there's a need to be fair, and to be seen to be fair to those whose interests, reputations, or fortunes may be adversely affected by the proceedings. Secondly, the need for the proceedings to be conducted with efficiency and as expeditiously as possible. And thirdly, that the costs of the proceedings need to be kept within reasonable bounds. But he said the golden rule is that there should be procedural flexibility, with procedures tailored to suit the circumstances of each inquiry. And so the points that I want to make now and share with you may not suit the inquiry in which you have to be engaged, or they may not, but at least I've tried to choose points that may be of general interest. The first point for a chairman is you very often get invited to meet the sponsoring body, be it the minister or whatever. And that's an opportunity to deal with a number of points that I think are important. The first of these, obviously, is the terms of reference, because sometimes terms of reference are drafted in a way that either inhibits the inquiry or otherwise are not wide enough to cover the points that really are of public interest. And so I think some input into the terms of reference, if possible, is useful, or that's a useful tool. The second point is on the meeting, is that very often, and particularly here in Northern Ireland, the government has put in time limits and said the inquiry should be conducted within a certain time and the report should be published within a certain time. And a recent inquiry into child abuse here, which was very successful, run by the late Sir Anthony Hart, they were given a period of time to conduct their inquiry, and he actually had to ask for an extension. And I think that's not a good thing, because nobody really knows how long an inquiry will last. And secondly, if you do have a time limit, even if you're given the power to ask for an extension, it looks bad from a public point of view that you've had to ask for an extension. He was given 6 months in which to report and managed to do it, but only just, as he said himself. And again, I think, for my part, I think probably looking back on the fingerprint inquiry, it would have been a good thing if I had been given a shorter time, a fixed time in which to report. But he suggested that 6 months was too short and that it should be at least 9 months. And I think this must depend upon the nature of the inquiry, because some inquiries you can begin writing as you go along because it falls into separate sections. Other inquiries you have to wait to the end before you can begin writing at all. The third point about the preliminary meeting is who is to publish the report. Again, I'm of the view that if possible, the chairman should publish the report. Under the Act of Section 25(2), that power can be given, which resides with the minister, but it can be given to the chairman. And if possible, I think the chairman should have it, because first of all, if you give it to the minister, then if he has the power, he can take as long as he likes to consider, or she can take as long as they like to consider the report before publishing it. But if the chairman has that power, he can give the sponsoring body a limited time in which to consider it. And secondly, the body setting up the report can choose when they'd like it published, when it was with a small p political to do so, but the chairman can get on with it and publish it as soon as he or she likes. And the third point, which I make reluctantly, is I think it avoids leaks if the chairman has control over publication. Turning now to the hearings, the initial hearing is important because people are expecting to see action, but as we all know, it takes a long time to set up an inquiry, and time spent in preparation actually saves time in the long run. But people want to see action, and I think it's worth having an initial hearing, if only to explain that it will be time before the proper hearings can begin. And it also gives an opportunity to appoint, to assign core participants and give them time to prepare also for the first proper hearings, if I might describe them as such. And the only warning I would give is that I think, looking back on it, it is tempting to appoint core participants at that early stage. But I would only appoint the most obvious ones, because you can always add others at a later stage. As for the hearings themselves, I have little to say about that. Obviously, the transcript is very important, and it's important not only for the tribunal that is hearing the evidence, but also for the witnesses, so that they have an opportunity to look at their evidence and maybe correct something that was wrong, and to be satisfied that their evidence is recorded exactly as they wish to give it. I would make one point about cross-examination, and that is, it is important to remember that a witness, as someone put it, doesn't have a case to make, to propound, but evidence to give. And therefore, I value the idea that counsel for core participants should have the opportunity to talk to counsel to the inquiry and to ask them to make a point that they wish to have developed, rather than ask for leave to cross-examine themselves. And this was used very successfully in the Bristol Royal Infirmary inquiry, where I understand they had no applications for cross-examination whatever. And I think if it's done sensitively and skillfully by counsel to the inquiry, it saves time, it saves expense, and I think it can be done calmly and without rancor. And so I would encourage, where possible, that counsel for participants should liaise with counsel to the inquiry and use that opportunity to have points made that they wish to have made, rather than do it themselves. At a later stage, before preparing the report, one has to consider warning letters. And here I would put in fairly strict time limits. Someone has suggested that 2 weeks, if you're given if your reference in the report is a very short one, or 4 weeks as an absolute maximum. These are all general points, which I hope are worth making, but I would just go back once more, just before I finish, that I think costs are a very important feature. It's remarkable that the Bloody Sunday inquiry into the shooting in Londonderry cost 200 million. And that really makes one stop and pause as to how we can cut down the costs of public inquiries. And the Institute for Government has said that in 10 years, 640 million has been spent on public inquiries. And I hope that we can somehow find a way to make them less expensive. The final thing I would wish to say is this, that whatever you do in chairing an inquiry, some people will say it's a whitewash, others will say that you've picked on someone as a scapegoat. You can't really satisfy everyone, but one thing that is very satisfying is that when you make recommendations and they are actually implemented. And for my own part, I was really impressed that the Scottish Police Authority Forensic Science Services, forensic services, became, 5 years after we finished the fingerprint inquiry, became, I think I got this right, the first large-scale provider in the UK to receive accreditation for its fingerprint activities. And it does show that the inquiries can result in improvement for the public in general. And that, I hope, is all I would like to say at present. Thank you.
Thank you so much, Sir Anthony. Normally there would be a round of applause now, but obviously with the limitations of Zoom, I'm very happy to give you a very small round of applause from me, but I'm sure it would be reflected by others also. I think that has been,
thank you.
I think that you have made some extremely interesting points. As you know, there have been 2 public inquiries announced in Scotland. The Hospitals Inquiry, chaired by Lord Brodie, which has officially started and the work is ongoing at the moment. And the Sheku Bio public inquiry, chaired by Lord Brackadale, which is not officially started, but preparations are ongoing. The comments you've made about liaising with counsel to the inquiry and cross-examination are very interesting. I think some of the potential core participants in these inquiries, perhaps if they've not been involved with public inquiries before, will be more concerned about the lack of cross-examination than anything. So your comments are very interesting, and I think will probably provoke some questions in chat. Are you happy to stay with us or to return to us at the end of today's session if there are questions?
Yes, of course. Yeah.
Would you be happy to do that? That'd be very helpful. People may know that they can use the chat function at the bottom of the screen, and they can add questions as we go along. And Gavin and I will try and keep on top of those and maybe come back to you at the end of today. Thank you very much. That's lovely, thank you. I think now we'll turn to our next speaker, who is Emma Toner. Emma, would you turn on your video? Hello. And unmute yourself if you remain muted. Emma is very experienced in relation to inquiries of all sorts. And at the moment, as I understand it, she's now been instructed to act in the Hospitals Inquiry, which is ongoing with Peter Gray, who we'll be hearing from later. Emma has been involved in some very high profile inquiries. She's been involved in the longest running inquiry into the Rose Park care home. That's the first inquiry I think you did when you started at the bar, Emma. And since then, you've really specialised in that field. And recently, you've been in the Sombra inquiry, which was done completely online. And you've also been involved in the Clutha Bar inquiry as well. So Emma's going to speak about the key differences between fatal accident inquiries, which are much more common in Scotland, and the differences between those and public inquiries. So Emma, I think I'll just turn over to you if you're ready to proceed.
Thank you, Angela. Thank you very much for that introduction. Well, thinking about public inquiries as we are today, I think it might be said that perhaps the two greatest themes which exist in the public inquiry process are, first of all, that of a full inquiry into an issue or issues of public concern, and secondly, the focus on past events with an eye to the future. And so I think to that extent, public inquiries do bear some similarity to fatal accident inquiries in Scotland under the 2016 Act, in as much as their shared purpose in a broad sense is examination of circumstances giving rise to public concern with an eye to how such events or circumstances might be rectified or simply avoided going forward in the future. So those really are the broad areas of commonality between public inquiries and fatal accident inquiries in Scotland. And I'm going to have what will necessarily be a brief overview of the main differences between the two sets of procedures. But before doing that, just some thoughts, first of all, on the features which these procedures have in common. Both forms of inquiry are provided for by statute. So with public inquiries, they're provided for by the Inquiries Act of 2005, which is UK legislation, and with fatal accident inquiries, it's the 2016 Act of the Scottish Parliament. And both forms of procedures also have accompanying sets of rules, which essentially set out how matters are to be run. Permission from the court for participation of parties is required for both procedures also. So for fatal accident inquiries under the 2016 Act, there is provision in the Act for intimation of a fatal accident inquiry on certain categories of individuals, certain categories of organisations, beyond which permission from the sheriff is required to participate in the inquiry. That can be contrasted with court participant status in an inquiry under the 2005 Act is a matter for the chairman of the inquiry to determine. Both forms of procedure, public inquiries and fatal accident inquiries, are set up with a fairly specified remit into the matters being inquired into. For a public inquiry, there are the terms of reference, and there are issues which are determined by the Crown for a fatal accident inquiry. So having a look now, what are the main differences between the two forms of procedure? And I think perhaps the biggest and most obvious difference to remark upon at the outset is that FAIs, fatal accident inquiries, are restricted into inquiries into deaths, whereas public inquiries are wholly unrestricted in terms of the matters which can be explored. There are differences in how matters run procedurally in each also. Public inquiries are also far more rare than fatal accident inquiries. In Scotland, since the 2005 Act was enacted, there have been 4 public inquiries concluded in Scotland, and 4 are ongoing or announced and either at an active stage or open or under preparation. And those are the hospital's inquiry, the inquiry into the death of Sheikh Obayo, and you'll know better, Angela, what stage that one is at, certainly at a very early stage. There's the ongoing child abuse inquiry and the trams inquiry also, which is yet to conclude. So they are far more rare than fatal accident inquiries themselves. And another important difference is how these respective sets of proceedings are actually brought about. Public inquiries are a government-initiated process. So in terms of Section 1 of the 2005 Act, the relevant minister in government, whether that's in the Scottish Parliament or jointly in Scotland, at any rate with Westminster, if the inquiry is relating to a matter which isn't devolved. So for example, health and safety isn't a devolved matter, and so when that was not within the sole competence of the Scottish ministers when at the time of the Stockline inquiry in 2008, The relevant minister in government requires to be persuaded that a public inquiry into an issue of concern is appropriate, and the process is initiated then from there. And that position can be contrasted with the position as regards fatal accident inquiries. These are set up by decision of the Lord Advocate within the context of the 2016 Act framework, but it's a matter for the Crown in those inquiries to put in its application to the court, which is really more of a notice to the court, and the court then sets the timetable for the inquiry proceedings. But a public inquiry, on the other hand, is a government initiated process, and then it is, once that's initiated, it is the chairman who directs matters from the start throughout and towards a conclusion, having regard to the terms of reference for the inquiry. Once the inquiry is set up and the chairman is appointed, the composition of the inquiry tribunal under the 2005 Act is really a matter for the chairman, and it can look quite different to a sheriff sitting alone at a fatal accident inquiry. The tribunal can take the form of a panel sitting with the chairman to advise the chairman. Panel members are appointed by the relevant minister, but only following consultation with the chairman, and the chairman can also sit alone. As regards terms of reference, whereas in a fatal accident inquiry, all parties are expected to positively state their position on what matters are likely to be in dispute at the inquiry, together with those matters that the sheriff might be expected to address in his determination. But in a public inquiry, the terms of reference are for the relevant minister to determine in the first instance. In terms of the conduct of the public inquiry itself, the rules provide that opening speeches can be made, and the legal representative of a court participant may, unless the chairman directs otherwise, make an opening statement to the inquiry at the outset, and can also make a closing statement to the inquiry. The explanatory notes to the rules indicate that that's a permission rather than directive, so parties can take the opportunity to do that, but they don't have to as a requirement. And there's no such feature in the 2016 Act in relation to fatal accident inquiries. Another main difference is in relation to questioning. Only counsel to the inquiry can ask questions of a witness at a public inquiry, and the permission of the chair is required for any line to be advanced by any other participant who seeks to ask questions of a witness. There's no particular time frame in the Act or the rules for notification of questioning or a line to be given, but permission for anyone other than the counsel to the inquiry to ask questions is required of the chairman. And that's a really significant power, and I think demonstrates the significant powers of management and control which are given to the chairman at a public inquiry. The rules also provide that warning letters can be sent out to those who have been or may be criticised during the inquiry proceedings or in the inquiry report, and the chairman can't make an explicit or significant criticism of any person in his report without first sending them a warning letter and giving them a reasonable opportunity to respond out of fairness. And it's usually clear from the outset in the terms of reference if the inquiry is concerned with serious allegations against an individual and or an organisation, and who those individuals and organisation are said to be. Also, whilst the sheriff in a fatal accident inquiry has a greater degree of management power than under the old regime in Scotland for fatal accident inquiries, there is a yet greater degree of control and management of proceedings by the chairman at a public inquiry. The Inquiries Act sets out that the procedure and the conduct of an inquiry are to be such as the chairman may direct. And for example, whilst the terms of reference for a public inquiry are for the relevant minister in government to determine, The Minister is required to consult the Chairman before setting out these terms of reference or before amending them. And it's interesting to note from Sir Anthony this morning, from the perspective of the Chairman, that having some input into the terms of reference is useful from the perspective of the Chairman. So really, to sum up, the similarities between these two forms of proceedings, the two forms of inquiry, they are similar in their spirit and purpose in examining an issue of public concern to try and learn lessons for the future to prevent recurrence of similar events. And in terms of the differences, public inquiries are far more rare. They are unrestricted in terms of the matters of concern which can be explored. They are a government-initiated process, and the Chairman of the inquiry will have a far greater degree of control and management over the proceedings than the Sheriff at a fatal accident inquiry. So I'll hand back to you now, Angela.
Thank you, Emma. That's been really interesting. I know that many people who are listening in today will be more familiar with FAIs, so that your summary of the distinctions, and quite marked distinctions between the two inquiries, will be very useful. Thank you very much. I think we'll turn on to our next speaker, who is Amber Galbraith. Amber, if you would unmute yourself and maybe turn your video on, if you're able to do that. Amber is very modest, obviously. Oh, there you are now. That's great. When I was looking to introduce you today, Amber, I did look at your CV on the Compass website, and it did strike me that you were very modest in your CV. And I think it's probably not a full reflection of your experience and the type of work you do. I've had the pleasure of working with Amber in many different fora and cases. Amber and I were involved in the fingerprint inquiry before Sir Anthony a few years ago, and I think it's fair to say, Amber, you were a calming influence on your side of the room. And I will say no more than that. But Amber's going to talk about a very significant issue for potential core participants, and that is the funding elements and recovery of documentation. So Amber, I'll just turn over to you now.
Many thanks, Angela, and good afternoon, everybody. As indicated, I'm going to discuss two topics: funding and recovery of documentation, and hope to highlight key issues for both areas. I appreciate that there's a variation in experience in our audience today, but with the time constraints we have, I aim to keep my comments quite general. So turning first to funding. The overall funding for a public inquiry obviously comes from government, and unless it's a joint inquiry, such as with Stockline, this means the Scottish Government. That funding will cover all aspects of the inquiry, which includes premises, inquiry personnel. But for us today, the important issue is what funding may be available for legal representation for those who become involved with inquiry proceedings, mainly core participants or perhaps witnesses. When an entity involved in an inquiry is a large organisation, such as a company or perhaps a union, the expectation is they will be self-funding. That was the position before the 2005 Act, and that remains the case. For individuals, legal aid is not available. Funding can be obtained from the inquiry budget for core participants and witnesses or persons requiring to produce documentation. And the legislative provision allowing for that can be found in Section 40 of the Inquiries Act 2005. And more detailed provision is given in the Inquiries Scotland Rules 2007. An award for funding under Section 40 can cover two things. Firstly, compensation for loss of time, and secondly, for expenses properly incurred or to be incurred. And it's obviously the second of these that's most significant, because Section 40 specifically includes an award for legal representation. And the legal costs of an inquiry often constitutes the most significant part of the total cost. As an illustration, for the Penrose inquiry, the total cost was about 12.1 million, but 5.15 million of that represented legal costs throughout the whole inquiry. Sir Anthony has already commented on the costs of inquiries, and obviously that will be influenced on the extent of public funding available for legal representation. An application to the inquiry for funding is regulated by Rules 17 to 28 of the 2007 rules. And in addition to that, there will usually be a specific protocol produced by an inquiry which will set out their own approach and procedures. So the Scottish Child Abuse Inquiry has its own cost of legal representation protocol, and you can find that on their website. That sets out the process in simple language and provides an application form. So I'd like to highlight some key points in relation to funding applications. Firstly, an application to the chair can be made at any time. But the clear preference is for that application to be made before any costs are incurred. The Child Abuse Inquiry Protocol provides that this is an extremely important point. Secondly, there has to be a full written application to the chair, and the chair has discretion as to whether or not to make an award. So there's no automatic entitlement to funding, and that decision will be a final one for the chair to make. When determining an application, the chair must take into account two criteria. Firstly is the financial resources of the applicant, and secondly, the public interest in making an award. So the chair will be looking at whether an individual has other sources of help, which could be a trade union or an insurer. For example, in the Trams inquiry, there were company directors who had individual insurance and had separate legal representation. And as I understand it in the Trams inquiry, the chair applied essentially legal aid rules when considering an application. The application must state certain things, in particular the nature and estimated duration for the representation and the proposed hourly rates for the representation. When a chair determines that an award should be made, various conditions will be set, and those will include the nature and scope of work to be funded, hourly rates, and limits on the amount or hours to be paid. Now, by making such conditions in advance, it's easy to see how problems could arise during the ebb and flow of an inquiry. I've heard of an example in the Trams inquiry where a representative was provided with about 1 million documents 2 weeks before the start of evidence, but told they only had 40 hours a week to review them. So that sets 25,000 documents an hour, which is quite a feat. The actual amount that will be allowed following the award by the chair is a matter for the solicitor to the inquiry, not the chair. And in relation to expenses already incurred, they will have to consider if they're proportionate and reasonable. And unlike the chair's initial decision, this assessment is subject to review. If it's challenged, the solicitor must reassess the amount, and if there's still a dispute, then the chair can direct that the matter is referred to the auditor of the Court of Session. An obvious issue that can arise in relation to funding is where a company or large organisation is involved with an inquiry, but there are individual employees who may be required to give evidence or may themselves face criticism. This clearly could be a conflict of interest where in a situation where an individual employee would be unlikely to be able to finance separate representation. As indicated in the Trams inquiry, directors had their own insurance and were separately represented, but I understand the council agreed to provide representation for employees, but then that within the legal team that can provide issues and constraints which can be challenging. So those are the key points I wanted to mention about funding. Turning now to recovery of documentation, initial requests can be made by the inquiry but for a number of reasons that may not be fruitful. There may be just an unwillingness to comply, or there may be a concern about consequences of disclosure. Section 21 of the 2005 Act gives an inquiry significant powers to compel disclosure of evidence. A chair can issue a notice requiring production of documents in two ways, by either requiring a person to attend at a particular time and place to produce documents, or to produce them within such a period as is reasonable. Effectively, this is a power for the inquiry to issue a specification of documents, and a person faced with a Section 21 notice must respond to the inquiry. There are two grounds for providing a negative response, and they're set out in subsection 4 of Section 21. A person may argue, firstly, they're unable to comply with the notice under this section, or secondly, that it's not reasonable in all the circumstances to be required to comply. So on receiving a response like that, the chair may revoke or vary the notice. And the test to be applied by the chair is set out in subsection 5. They must consider the public interest in the information being obtained by the inquiry and the likely importance of that information. So if a person's just simply not able to respond, that's likely to be where the information just cannot be found. But a person, I would suggest, will have to be able to explain clearly and quite robustly why that's not the case, and reassure an inquiry that appropriate efforts have been made. The second ground is perhaps a little more nebulous, being whether it's reasonable to comply, and the chair will have to balance that reasonableness of the request against the public interest and importance of the information. So if a client receives a Section 21 notice, they will have to provide a full report to the inquiry explaining their position and detail what they've done to find documentation, where they've looked, what hurdles they face, and why it is not reasonable to provide the information. In terms of confidentiality, as with specification, if documentation has to be produced, it should be handed over without redaction. If there's a concern about confidentiality, an application can be made for the inquiry to make a restriction notice in terms of Section 19 of the 2005 Act. And that will allow for restrictions to be imposed either on attendance at the inquiry or disclosure or publication of evidence or documents. Some inquiries may make a general restriction order, as has happened with the Scottish Child Abuse Inquiry. And the latest one provides that the identity of anyone claiming to have been abused, anyone alleged to have been an abuser or a child in care, will be protected. Due to constraints of time, I will not go into the detail of this case, but I would refer you to the recent case of Bilfinger Construction UK Limited against Edinburgh Tram Inquiry. That's set out in the handout. Bilfinger had produced documents to the inquiry which it said were commercially sensitive. It sought a restriction order, and that was refused by the chair. So Bilfinger then went to the Court of Session seeking interim suspension of that decision and an interdict from publishing the information. And that was unsuccessful at first instance before Lord Tyre and on appeal. Just briefly then, in relation to public interest immunity, Section 22 of the 2005 Act gives witnesses the same privileges in relations to requests for information in a public inquiry as they have in a civil action. So if there's a legal professional privilege being claimed, then that can be argued in the same way. Lastly, if there's a failure to comply with a requirement under Section 21, it is a criminal offence which carries a sentence of 6 months imprisonment. But an alternative approach is that Section 36 of the 2005 Act provides that where a person fails to comply with or acts in breach of a notice under Section 19, the restriction notice, or 21, or they threaten to do that, then the chair may certify the matter to the Court of Session. They can then hear the evidence or representation and can make any order by way of enforcement or otherwise as it could make as if the matter had arisen in proceedings before the court. So that's an option to approach the chair to ask the Court of Session to resolve the issue. So this has been a very brief outline of key points, and a copy of the talk will be available on the website. So with that, I shall pass back to Angela. Thank you.
Thank you so much, Amber. Those are really essential issues that you've discussed. And so that's very helpful advice to people. You mentioned a handout, and just for everyone who's listening, Gavin will be sharing that with everyone in due course. So thank you for your talk, Amber. I'd like to turn quickly to the next speaker. He really needs no introduction. He is, as I said earlier, now acting for Greater Glasgow Health Board in the hospital inquiry. And I wonder, Peter, if you could turn your video on, please. He is one of the leading practitioners in Scottish health and safety. He's very calm and measured, and he has the ear of the court. And it's not just me that says that, it's Chambers who are saying that, Peter. So that's your instructing agents that have given those comments to Chambers. You're going to speak about preparation for public inquiry hearings. I'd like to turn to you now. Thanks.
Thank you very much, Angela. Well, good afternoon, ladies and gentlemen. The adage, fail to prepare or prepare to fail, is perhaps of relevance to everything that we do as lawyers. But I think it's particularly apt in relation to public inquiries, where the legislation permits a very wide discretion as to how the inquiry is conducted from its inception to its conclusion. With the consequence, I think, that each inquiry is truly unique. And therefore, as lawyers, we require to be prepared for every eventuality. And it may seem obvious, but I think that a good starting point in preparation for any inquiry is to have and to develop an intimate knowledge of both the Act and the rules, both of which are commendably brief and appear straightforward. But the reality, as always, is that the devil is in the detail. And I think that if you develop an intimate knowledge and understanding of the detail, that will prove to be invaluable in navigating your client through what for them may well be a demanding and onerous process. And secondly, as a starting point in preparing for an inquiry, I think it is essential to have by your side at all times the terms of reference of the inquiry and to have a clear understanding of them. Because whilst the statute does indeed permit a very wide discretion to the inquiry panel as to how the inquiry is conducted, and provides the panel with extensive powers, it is nevertheless required to operate within those defined terms of reference. And I think it is also essential at a very early stage to prepare the client for the inquiry and to manage their expectations, because they may well have preconceived notions about the format that an inquiry may take. They may have a sense that it will be no different to traditional litigation. And if that is the case, then it is really essential that they should understand the truly investigatory and inquisitorial nature of the inquiry, both in the preparatory stages and at the hearing itself. And it's essential that they should understand the demands which may be made of them by the inquiry panel. And whilst Steve Love will be highlighting in his talk the fundamental differences between an evidential hearing at an inquiry and what we and perhaps clients are more accustomed to at a proof or a trial, I shall focus on the preparatory stage. And like Amber, and it overlaps to some extent, but it is very important, would like to look at the Section 21 notices. And I do so because unless you're representing a core participant, the receipt by your client of that notice and their frantic call to you seeking advice may be your first involvement in a particular inquiry, and you're faced with a client who has perhaps neither the time, resource, or inclination to address the wide-ranging demands of a notice, and will be wanting to know what their options may be. And Amber has set out what the powers of the inquiry panel are under Section 21, and in particular under Section 21(2)(b, to require any person within such period as appears to the inquiry panel to be reasonable to provide any documents in his custody or under his control that relate to a matter in question at the inquiry. And so it's clear that depending on the precise terms of the notice, that requirement may indeed be both onerous and time-consuming. So in addition to some of the matters that Amber looked at, in considering whether your client requires to comply with a notice, you may wish to consider the following, almost as a checklist in any case. And firstly, to ask yourselves, well, is this inquiry a UK inquiry, as it was in the very first public inquiry held under the Inquiries Act of 2005 in the Stockline inquiry, or is it a Scottish inquiry? Because whilst both are governed by the Inquiries Act of 2005, the scope of what may be required to be produced under Section 21 orders differs according to what type of inquiry it is. And that's governed by Sections 27 and 28. And you might also want to ask yourself, well, does what is being sought truly relate to a matter in question at the inquiry, as is required for a valid Section 21 notice? And so the terms of reference of the inquiry are a useful starting point for you in considering that issue as well. As Amber has said, of course, you want to consider whether the information that's been sought is privileged, because if it is, there is no requirement to provide that documentation under Section 22. But you also might want, in discussing the issue with your client, to look in more general terms and to establish, well, what would be the time, the cost, the resource involved in providing the information? Because if it is significant, you may be able to argue that it is simply not reasonable to expect your client to provide the information sought, and therefore to rely upon one of the bases upon which a notice need not be complied with. I think it's also important, however, when you're looking at a Section 21 notice, to think out of the box, to bear in mind that from the perspective of the inquiry team, they may be making a request for information which may have extensive schedules attached to it, without knowing precisely what information and what documentation your client has. And it may be that unknown to the inquiry panel, there is one or perhaps a couple of documents which provides all that the inquiry panel requires, rendering superfluous and unnecessary much of what is being sought, and therefore making it unreasonable to expect your client to comply with each and every detail of the notice. So those are just some of the issues which you may wish to consider as a matter of course in any case, in addition to those which have been identified by Amber. And as Amber indicated, where there is a dispute, it may be resolved by decision of the chairman of the inquiry under section 21(4). But I would like to think that in most cases where there is a dispute or where the notice is contentious, that a more informal approach may be preferable, at least in the first instance. And that is to engage with the inquiry team. And in terms of preparation for an inquiry, I would suggest that early engagement with the inquiry team is essential with a view to developing a positive and constructive working relationship. And if you do that, it may well be that section 21 issues, for example, can be resolved without rancor to the benefit of your client. So those are just some high-level thoughts on the approach which you may wish to take when preparing for an inquiry and issues which you may wish to consider, and I hope have been of some assistance and interest. So thank you very much.
Thank you, Peter. That was very interesting, especially as you're the first person to mention privilege as an issue in relation to that. And I think that is something that will be concerning potential core participants for the inquiries which are coming up. We're starting to get a few questions in, but if you don't mind, what we'll do is we'll move on to our final speaker today, and we'll come back to the Q&A at the end. Thanks very much, Peter. I'd like to turn to our final speaker, who is Steve Love, one of the directors of Compass. He's been heavily involved in the Scottish Child Abuse Inquiry, and I know that he has some very interesting comments to make about representation of core participants at the inquiry. Steve, if you are ready to, you've got your camera on, and I'll just hand over to you. Thanks very much.
Thanks very much, Angela. Over the next 10 minutes or so, I'll look to provide both general and specific observations about issues that arise once a public inquiry is up and running. As has already been alluded to by all of today's speakers, it's important to know the Act and the rules inside out and back to front. As regards the conduct of hearings, reporting restrictions, anonymity of witnesses, and the disclosure or publication of any evidence or documents, you should have to the forefront of your thoughts any guidelines, protocol, and any general restrictions orders issued by the chair, as well as any undertakings that have been given by you and your client. You will have reviewed in detail the disclosure made by the inquiry team with a view to identifying areas of potential difficulty for your client. From personal experience, I'd recommend getting to grips with the inquiry's document management system at the very earliest opportunity. Accept all the training and guidance that's offered, it's invaluable. Core participants and their legal representatives are subject to directions by the chair entitled to be involved throughout the course of an inquiry. A core participant may have been permitted to be active throughout the whole inquiry, for an extended part of it, or for designated parts of it. And it's important to appreciate that core participant status carries with it undeniable advantages, including an entitlement to documentary productions, transcripts of evidence, the right to ask for permission to ask questions, which failing the right to propose questions to counsel for the inquiry. There's also the entitlement to see the draft report before it's published, and the right to comment on that draft. Essentially, the core participant ought to have prior notice of the likely lines of attack from the key protagonists and potential adverse findings from the inquiry panel. This prior notice has hopefully afforded time to ingather exculpatory evidence. So given the time that's been allotted, I'm going to focus on three particular factors. The opening statement, evidence generally, and the closing statement. Looking at the opening statement, as Emma has already said, the making of an opening statement is not compulsory, it's not a requirement. But what I would suggest is that it might be seen as an opportunity to present a plea in mitigation in advance, an unusual scenario. If the decision is made to present an opening statement, it's likely to be your baptism of fire at the first of any inquiry hearings. The chair will have determined who's allowed to give an opening statement, and once Inquiry Council has provided an outline of what the inquiry will cover and the intended order of witnesses, organisations taking an active part in the inquiry may be given the opportunity to make an opening submission. It's reasonable to assume that there may well be criticism in the press for what you do say, and of course for what you don't. And there's a presumption in the Act that members of the public will be able to watch the inquiry and secure access to evidence and documents. All of that being so, great care requires to be taken in preparing and taking instructions on the content of any proposed opening statement. The form or length of any opening statement is at the discretion of the chair, and consideration may be given to looking at positives as well as negatives. While acknowledging where wrongs were done, for example, you may also look at changes that have been made, perhaps even in consequence. The opening statement may be a suitable vehicle for, as appropriate, making an apology or apologies, or declaring a commitment to avoid wrongs in the future, and stating a commitment to engage with and assist the inquiry in addressing its terms of reference and objectives. As Peter said in his talk, the motto, be prepared, applies. As you narrate your well-prepared opening salvo, there may be hand grenades thrown in by the chair, who will, along with other members of the inquiry team, have had advance notice of the content of your statement and had an opportunity to identify questions. You need to be on top of your facts and, of course, take great care not to exceed your client's instructions. If you can't answer, then seek a brief adjournment to obtain instructions. And examples of opening statements can be found on inquiry sites or by focused Googling. Turning now to the issue of the questioning of witnesses. Once the opening statements are out of the way, the evidence begins. Evidence can be given in person, remotely, or by means of a statement or a report being read in. Only Inquiry Council or the chair may of right ask questions of any witnesses, whether lay or expert. And litigators accustomed, as most of us are, to working within an adversarial system may find the public inquiry process more than just a little frustrating, and it may require greater or lesser levels of tongue biting. It's a different mindset from litigation, mediation, or arbitration, a totally different beast. It's a fluid process, and to a certain extent, you're cut free from all the usual factors that give you comfort and a feeling of control over matters that impact on your client's position. The Act doesn't dictate what standard of proof an inquiry should use, and that's left up to the chair. There are no written pleadings, there's no charge, there's no capacity to object to leading or what you might perceive to be shamelessly loaded questions. There's no entitlement to lead your own factual or expert evidence, no practice notes and disclosure, and the process is completely at the discretion of the chair. As Peter has said, explaining all of this to your clients of key importance. They'll have an expectation of what the process is likely to involve, but unless they've had prior involvement with a public inquiry, their expectations are likely to come from Rumpole, Kavanagh QC, or something like Suits. A public inquiry is an inquisitorial process. The inquiry team is acting in the public interest. They should be neutral in their conduct and seek to take evidence in a manner that's free from emotion or prejudice. Some Inquiry Council may find that more difficult than others. It seems to me, and it's echoing what Sir Anthony and Peter have said, that the only way to look to exert control is to communicate or to seek to communicate in advance with the inquiry team. And that being so, my top tip, I suppose, if that's the right way of looking at it, is that you should endeavour to create a positive line of communication with the legal team to the inquiry. Pick up the phone, arrange a meeting in person to discuss issues. There's considerable benefit in counsel-to-counsel chats. Counsel to the inquiry are, of course, a direct conduit to the chair, and if they're approachable and experience suggests that they are, then you should make good use of that. It's important to bear in mind that the inquiry solicitor may not be a litigator, will not necessarily be familiar with the court processes, and may not be up to speed with procedures, so to be forgiving. Looking at witness evidence generally, it's ultimately a matter of balance, and very much will depend upon the subject matter of each and every inquiry and what lines of inquiry are taken. Whereas can happen, the timing of disclosure of evidence makes it impossible to provide advance notice of questions in line with any protocol or guideline. It has to be hoped that the inquiry team will adopt a sensible and pragmatic approach to questions. In the Scottish child abuse inquiry, for example, the protocol provides that witnesses are usually asked questions only by inquiry counsel, but those actively participating could propose questions for inquiry counsel to ask, may be invited to ask questions, or may seek the chair's permission to ask questions. Only inquiry counsel and the chair have an unqualified right to ask a witness questions. Moving on finally to closing statements, once the evidence is concluded, those with leave to appear will be invited to make such closing statements as are appropriate. The same applies, as was said earlier, in relation to opening statements, including the need to beware of hand grenades. It's an important opportunity to address the evidence that's been led insofar as it affects your client. And again, great care requires to be taken in preparing and taking instructions on the content of any closing statement. There are other issues that would have merited cover today, including judicial review or Section 36 applications, where the inquiry seeks enforcement via the Court of Session, but those issues would merit a seminar in their own right. So with that, I'll conclude my talk and pass you back over to Angela.
Thank you very much, Steve. That was chock full of good practical advice, and you managed to resist naming names or being critical of anyone in the circumstances that you've found yourself. I think we'll move straight on to the question and answer session, if that's okay. We're just ever so slightly out running over our time. I'd like to begin, first of all, with one of the questions we've had. Sir Anthony, if you wouldn't mind dealing with this, it's just some suggestions or tips that you could provide to any counsel who are acting for a core participant, and how they could be an effective advocate within the constraints of how public inquiries function. Do you have any sort of comments to make?
I'm not sure. I've had trouble with my sound, but I hope I've got the question again. If you would, please.
For any advocate or counsel or solicitor advocate representing a core participant at a public inquiry, do you have any suggestions or tips on how they can be effective advocates, how they can best represent their clients at the inquiry hearings?
Well, I think the main point which has been made by more than one speaker today is that as long as they can understand that they're not in an adversarial position, then I think it goes much better and suits the inquiry more, because what one's trying to do is to find the facts. And that is the whole purpose of the inquiry. And I think if counsel can concentrate on the fact that they're not in a defensive position, but merely putting the facts before the inquiry, then I think it goes rather better than it would otherwise if they get into a position in which they're trying to defend something which they don't have to defend.
So maintaining that mindset of being in an inquisitorial environment is something that counsel could probably practice and keep practicing as the inquiry goes on.
Yes, I think it's something that even the inquiry panel have to keep reminding themselves that it's inquisitorial and not adversarial. There are times it's hard to remember, to keep that in mind.
Yeah, I think that's very good advice, actually. And then the next question that we have is really to all the participants or anyone who'd be interested. This comes from Mr. Anwar. In his experience of representing a family pro bono, that's been going on for a number of years, but he's very keen to hear how should those representing the family begin their approaches to preparing fully, where they do not have funding, and if there is a cap on 40 hours a week, there's a concern that where the public authorities involved and the Crown and such like are able to put teams of people onto their preparation, how can the family have equal time and resources to prepare? Does anyone have any comments on that? Amber, I know, sorry to pick on you there, but your talk was about funding. Would you have any suggestions about preparation when someone's acting for the family? Do you want to say anything about retrospective applications for the work already done, or does it come down really to good communication and making sure you know what's happening as soon as possible?
Yeah, I appreciate it. I mean, it is a very difficult situation, as you say, with a balance of power and funding can seem very unequal, and it's difficult with a public inquiry constrained with that balancing exercise. The 40 hours a week was an example given for the trams inquiry, so I don't know to what extent that's reflective in other inquiries of such restriction, and it's very difficult, I appreciate, to anticipate in advance what you may have to deal with when you don't necessarily have all the information. You're getting information from the inquiry. It's extremely hard to do that. In terms of practical steps for the basic application process, there is a process by which, if there's a continuing dispute between the inquiry, if it cannot be resolved, then that can be referred to the court of the auditor of the Court of Session. But I imagine that has to be a very sort of last option. The hope would be that by cooperation with the inquiry team, that assistance can be given by way of documentation or summaries or whatever between the parties without having to take those kind of steps.
So for Mr. Anwar, so cooperation with the inquiry team at an early stage, early applications for funding, early application to become a core participant, and quick access to documents once they start being recovered. And all of that would hopefully help. Yeah. Okay, great, thank you. There was, Peter, you spoke about a Section 21 notice, I think, at one point in your talk, and we've had a question from David Hennessy. Can persons apply for funding in order to comply with a Section 21 notice? Would you want to make any comment about that?
Could I interrupt or interject before Peter kicks in? The one thing that has been apparent to me, given my experience in the child abuse inquiry of late, is that companies and public bodies can participate, but they're going to expect to be self-funding. So companies and organisations and public bodies are unlikely, I would have thought, to meet with much favour if they apply to the chair for funding. In terms of an application to the chair for funding, it seems to me that, as with everything, it's a discretionary matter for the chair, and it's up to the applying party to provide sufficient information to enable the chair to make a decision. But again, the conduit is going to be via the inquiry team, and having lengthy discussions with Inquiry Council to find out what the the thought processes are, might be a helpful way forward, because ultimately, of course, what the chair has to do is to give, if approval is granted to the application, is to look at the nature of the scope of the work to be funded, applicable hourly rates, and looking at upper limits on the sums and the number of hours that will be paid. So all of these factors are the prescriptive limits that need to be set within the confines of Rule 19. But again, coming back to what Peter said in his talk, it's all about being prepared. And the same goes for every stage of the inquiry, including an application for funding.
So it seems that it's the most helpful thing to do and to move forward really is to keep good communications with the inquiry team. And again, tying in with what Sir Anthony and others have said, they're not the enemy. They are a group of people who should be there and can provide help and assistance. And it's not an adversarial discussion with them. The other thing that might be of interest to Mr. Anwar is, although there might be a 40-hour-a-week cap, there'll always be ways to negotiate that up in this particular circumstances. So it shouldn't be seen as, you know, a red line that in the sand that can never be changed. Right, sorry, Peter, I was wondering if you wanted to answer the question about the Section 21 notice. Can persons apply for funding in order to comply with the Section 21 notice? Are you on mute, Peter? Sorry, I think you're on mute. You'll have to unmute your screen.
I have unmuted now, I hope.
Thank you.
So it's helpful that I've unmuted. What is less helpful is that I'm not sure that I have the answer to this particular question. I mean, obviously there's that general power available under Section 40, and then awards that can be made of funding under Rule 19. But exactly what the mechanics would be when faced with a Section 21 notice, I'm not entirely certain. So I don't know whether anybody else can give a more informative answer into that relation to that very good question.
Well, maybe the answer is, again, from the fact that we're encouraging everyone to speak to the inquiry team. The solicitor to the inquiry has a key role in relation to funding. So, for example, in the inquiry I'm involved in, Sadaf Ashraf would be in a position to speak to people and discuss that issue. And maybe that is the best place to start. I mean, we've also heard, and I can't remember who spoke about it, but protocols for funding. I think someone mentioned the protocol for funding in the child abuse inquiry. Was that you, Amber? And other inquiries will have protocols as well. So probably that's a key resource in relation to these questions too.
Yeah, I mean, I think in terms of, as Peter said, in terms of the legislation, in theory, someone who requires to produce documentation could apply for funding. But again, bringing in what Steve said, if that person is most likely to be a large company or organisation rather than an individual, then it may be unlikely that will be granted. But I think that the powers there, I think, you know, in theory, to apply for the funding. Yeah.
Thank you. Well, I think we are officially 3 minutes over our time now. And I think people, I know myself, watching Zoom and listening can be involve quite a lot of concentration. So can I just finish today by thanking all of our speakers, particularly you, Sir Anthony, for joining us from Northern Ireland, and to all the people who are fellow members of Compass Chambers. I personally have really enjoyed all of your talks. I've taken lots of notes, which I'll use for my own benefit later. The slides or the handouts will be sent round to everyone who's registered and watched today. And thanks to everyone for your questions. Obviously, if there are still questions coming in, but if there's particular things, everyone can obviously be contacted via the Compass website. So thank you, and thanks to our clerk, Gavin, for organising this all bringing it all together. And thank you very much. I think that's the end of today's session. Thank you. Bye.